Theft is committed by any person who takes personal property of another without the latter's consent, with intent to gain, but without violence against or intimidation of persons, or force upon things. Article 308, 1947, and 1949, bar exam. X. A cargador riding on a truck hauling cases of milk belonging to Seagate Company threw out 2 cases as the truck passed a certain street. A policeman witnessing the act immediately places X under arrest. The mere act of throwing by the offender 2 cases of milk while riding on a truck is consummated theft. Throwing out of said cases is in the legal sense taking the same. People versus Neville. Theft is consummated since the offender already acquired constructive possession over the cases of milk when they were thrown from the truck. 1955, bar. Theft is consummated when the offender unlawfully acquires possession of personal property, even if for a short time, or if such property is under the dominion and control of the thief. In theft, actual manual possession of property is not required. Constructive possession of the thief over the property is enough. Laurel versus Abrugar. Forest Ranger Velasco was patrolling Balara watershed and reservoir when he noticed a big pile of cut logs outside the gate of the watershed. Curious, he scouted around, and after a few minutes he saw Rennie and Dante coming out of the gate with more newly cut logs. Under PD number 330, cutting logs in a public forest constitute qualified theft. Rennie and Dante are liable for theft not only with respect to the newly cut logs found in their possession but also to those found outside the gate. The fact that they were caught in possession of newly cut logs gives rise to the presumption that they also stole the logs found outside the gate. 2006, bar. Asportation is not an element of theft. A personal property can be the object of theft as long as it is capable of appropriation, although it is not capable of asportation. Medina versus People. Intangible property is not capable of asportation, and yet it can be an object of theft. The subject of the crime of theft is any personal property belonging to another. Hence, as long as the property taken does not belong to the accused, who has no valid claim thereover, it is immaterial whether said offender stole it from the owner, a mere possessor, or even a thief of the property. 1958, bar exam. Miranda versus People. An owner of a necklace cannot be held liable for theft for surreptitiously taking it without the knowledge and consent of the store owner. 2018, bar. The subsequent recovery of the stolen property will not preclude the presence of intent to gain as an element of theft. Actual gain is irrelevant, as the important consideration is the intent to gain, or animus lucrandi. Intent to gain is an internal act presumed from the unlawful taking. September 2015, People versus Asamuddin. The gist of theft is the intent to deprive another of his personal property for gain. This cannot be where the taker honestly believes the property is his own or that of another, and that he has a right to take possession of it for himself or for another for the protection of the latter. 2018, bar. However, the belief of the accused of his ownership over the property must be honest and in good faith, and not a mere sham or pretense. If the claim is dishonest, a mere pretense, taking the property of another will not protect the taker. Gaviola versus People. This belief of ownership as a defense in theft is in accordance with the mistake of fact doctrine. X found in the street the amount of 2,000. He did not report his finding of the money to the proper authorities, nor did he return the same to the owner, whose address is inscribed in the bag containing the money. Instead, he used the money for his benefit. X is liable for theft. 1976, 2011, 2012, and 2015 bar exam. And because Article 308 says that theft is likewise committed by any person who finds lost property but fails to deliver the same to the local authorities or to its owner. A vagrant found a bag containing identification cards and a diamond ring along Rojas Boulevard. Knowing that it was not his, he went to the nearest police station to seek help in finding the owner of the bag. At the police station, the vagrant proposed to the police investigator, "In case you don't find the owner, let's just pawn straight to the pawn shop and pawn the ring for $50,000. The vagrant never saw the investigator again. The vagrant is not liable for theft since he delivered the lost ring to the police authorities. His proposal to misappropriate the ring is not punishable as theft under the law. Without externalizing his criminal mind, the vagrant is not criminally liable, since a felony is a combination of criminal intent and criminal act. The police investigator is not liable for theft, since there is no showing that he did not deliver the lost ring to its owner or has misappropriated it. The fact that the vagrant did not see the investigator again does not give rise to a reasonable inference that he stole already the property." 2008 bar exam. But when AB accidentally left her purse with $500 inside a taxi cab, the driver brought the purse and money to the police station and handed them to the desk sergeant with a request that they be delivered to AB, the owner whose name and address were on a piece of paper inside the purse. The sergeant did not do as requested, but spent the money. The sergeant is liable for theft. 1978, 1999, 2001, and 2015 bar exam. X. A bank teller received from a depositor, a check payable to cash in the amount of $1 million to be deposited to her account. However, X deposited the bearer check to the account of Y, her friend. After 7 days, X told Y that the amount of $1 million was wrongfully credited to her account and urged her to withdraw the money. X gave Y expensive Hermes bag after the withdrawal of the money. 2014 bar exam. Since the possession of X over the bearer check is de facto, depositing it to the account of Y instead of A shall be considered as taking without consent. Hence, the crime committed is theft with the qualifying circumstance of abuse of confidence. People versus Mirto. Using a stolen bearer check to defraud the bank is not estafa, since it was only employed to realize actual gain from stealing the check. In People versus Usai, the taking of the pawn tickets without the consent of the owner with intent to gain constitutes the crime of theft. The accused pretended that he was the owner of the pawned jewels, and without making use of the corresponding pawn tickets other than their respective numbers, he succeeded in redeeming them through the identification of his person. This pretension constitutes the crime of estafa. Theft of the tickets is a necessary means to commit estafa, because without the numbers of the stolen pawn tickets, he could not have identified the jewels and consequently would not have been able to redeem them. This is a complex crime of estafa through theft. Qualified theft is committed by any person who takes personal property of another without the latter's consent with intent to gain, and with any of the following qualifying circumstances. 1. Domestic servant. 2. Grave abuse of confidence. 3. On the occasion of fire, earthquake, typhoon, volcanic eruption, or any other calamity, vehicular accident, or civil disturbance. 4. Coconuts taken from the premises of a plantation, or fish taken from a fish pond or fishery. 5. The property stolen is mail matter. Article 310. Employer-employee relationship is not an element of qualified theft with abuse of confidence. In People versus Serranilla, stealing funded traveler's check belonging to the bank by cargo checker of PAL is qualified theft. The fact that the bank, which is the owner of the stolen check, is that the employer of the accused is of no moment. The relation of independence, guardianship, or vigilance between the accused and bank. The offended party makes the offense that of a qualified theft. Note: since the check owned by the bank is accessible to the employee of PAL, this is an indication that the former has confidence that the latter will not steal it. An employee who took company property is liable for qualified theft if the stolen properties are accessible to him. Because of the circumstance of abuse of confidence, making the property accessible to the employee is an indication that the employer has confidence in him that he will not steal the property. The employee abused such confidence by stealing it. If the accused as an employee had no physical access to or material possession of the stolen goods owned by his employer, the qualifying circumstance of abuse of confidence cannot be appreciated. Making the property non-accessible to the employee is an indication that the employer has no confidence in him that he will not steal the property. Breaking the main door because accused was denied access to complainant's house means that the latter has no confidence on the former. Qualified theft with abuse of confidence is not committed, but if the accused is a domestic servant, qualified theft is committed regardless of the non-accessibility of the property stolen and the absence of abuse of confidence. On occasion of calamity, a fire broke out in a department store. A, taking advantage of the confusion, entered the store and carried away goods, which he later sold. The crime committed is theft qualified by the circumstance of on occasion of fire. 2002. Coconut. Stealing of coconuts when they are still on the tree or deposited on the ground within the premises of a plantation is qualified theft. When the coconuts are stolen in any other place, it is simple theft. Stated differently, if the coconuts were taken in front of a house along the highway outside the coconut plantation, it would be simple theft only.